Hello, and welcome to the Federal Maritime Commission's presentation on its new interim procedures for filing and processing complaints about shipping-related charges assessed by common carriers, known as charge complaints. In this presentation, we will discuss the Commission's new authority to investigate charge complaints filed with the Commission and order a refund or waiver from a common carrier for non-compliant charges. We will also explain how to file a charge complaint and what to expect after you file your charge complaint. In June 2022, the bipartisan Ocean Shipping Reform Act of 2022, also called OSRA or OSRA 2022, was enacted into law and gave the FMC a number of new authorities and responsibilities. Under OSRA 2022, the FMC is responsible for developing and implementing a new streamlined complaint filing and investigation process specifically designed for shipping-related charges assessed by common carriers, both ocean common carriers and non-vessel operating common carriers, to include demurrage and detention charges. Effective on June 16, 2022, the new charge complaint provision, 46 U.S.C. Section 41310, authorizes the Commission to promptly investigate information concerning complaints about charges assessed by a common carrier, and then order refunds and/or penalties for charges that do not comply with 46 U.S.C. Sections 41104A and 41102. To ensure the shipping public was able to immediately seek relief from shipping-related charges, the Commission created an interim procedure to receive and process these type of complaints. A longer-term charge complaint procedure will be finalized in the coming year through the federal rulemaking and public comment process. The new charge complaint procedure is unique and different from the FMC's existing options available to the shipping public to seek relief. Before you contact the FMC for assistance with a complaint, it's important to think about what type of resolution you're looking for. Knowing what you intend to gain at the end of your complaint is helpful in deciding where to begin. Several options have been available at the FMC for many years. Did you receive and pay a shipping-related charge, and are you looking to get your money back? In this case, you may have more than one option to address your shipping-related problem. For example, you could file a small claims or formal complaint for a legal decision. This process can be lengthy and is subject to an administrative law judge's or a small claim officer's finding a decision. For a potentially faster resolution, you could use the FMC's Alternative Dispute Resolution Services to seek a commercial solution that quickly solves a cargo dispute without a judgment issued by a judge or a small claims officer. This option is a good choice if, for example, your cargo is being held by a carrier or a marine terminal operator for payment of a disputed charge, and your primary concern is to get your cargo released as quickly as possible. This process also allows the parties more direct involvement in fashioning the outcome. Alternatively, you may want the FMC to investigate an alleged Shipping Act violation and possibly impose a civil penalty on the shipping company, but do not want to file a lawsuit yourself. In this situation, you may want to report a Shipping Act violation. The Commission's new charge complaint procedure under OSRA 2022 provides an even more streamlined way to seek a refund or waiver of a disputed shipping-related charge. A charge complaint is a standalone procedure for relief at the Commission. If you decide to file a charge complaint, your filing cannot be combined with either the formal proceedings under 46 CFR Section 502.61 or a small claims, formal or informal proceeding under 46 CFR Section 502.301 to 321. If, after filing a charge complaint, the Commission determines that the charge was compliant with Sections 41104A or 41102, you can subsequently submit a formal or a small claims complaint. Additionally, in the event that an investigation of a charge complaint filing results in a determination that the charge was compliant, you can subsequently provide information to the Commission's Bureau of Enforcement, Investigations, and Compliance in support of a Commission investigation of other potential violations. Again, please note that these distinct processes cannot be combined into a single submission. For more information about the FMC's formal, small claims, and ADR processes, please review the Commission's Exploring Commission Complaint Resolution Processes webinar posted on the FMC's website. Now that we've quickly covered the Commission's existing complaint resolution processes, We'll focus the remainder of this presentation on the Commission's new charge complaints interim procedure.
Who can file a charge complaint? Under 46 U.S.C. 41310, any person may submit to the Commission a complaint about charges assessed by a common carrier that they believe may not comply with Sections 41104A or 41102 of the Shipping Act as amended. A shipper, consignee, trucker, or third party who has paid such a shipping-related charge, or someone that has been invoiced or assessed for such a shipping-related charge, may file a charge complaint with the Commission. Charge complaints can include a broad range of non-compliant charges assessed by a common carrier. The new charge complaint process is appropriate for charges assessed after June 16, 2022, and charges that have been invoiced or billed. For charge complaints, assessed means that it's been invoiced or billed. A charge complaint should not be filed until the shipper has received an invoice or bill for the shipping-related charge in dispute. The charge must have been assessed by a common carrier. This is an important point. A common carrier means either a vessel operating common carrier or a non-vessel operating common carrier. If the charge was assessed by a marine terminal operator or another party, this charge would not fall under the new charge complaint process. A complaint can be filed regardless of whether the charges have been paid. If the charges have been paid and the Commission determines a Shipping Act violation has occurred, the remedy would be a refund of those charges. If the charges have not been paid and the Commission determines a shipping violation has occurred, the charges can be waived by the FMC through this process. Charge complaints must be wrongly assessed by a common carrier, meaning that they're not in compliance with 46 U.S.C. 41104A or 41102. Charge complaints can include a broad range of non-compliant charges assessed by a common carrier. However, charges assessed must involve transportation of cargo within the Commission's jurisdiction, for example, carriage of cargo in the U.S. foreign ocean-borne trades, and complaints must dispute an assessed shipping-related charge. While complaints about the reasonableness of demurrage or detention charge tend to be the most common, other carrier fees or charges not in compliance with 46 U.S.C. 41104A and 41102 may be submitted for investigation. The non-compliant charges may include demurrage and detention charges when there were no available appointments or the only appointments were restricted to dual turn only for multiple days during free time. D&D charges when the containers were unable to be retrieved from the terminal during free time. This may apply to terminal closures due to weather. This may apply to closed areas within the terminal. And this may apply to situations where the terminal was unable to locate the container. D&D charges when the carrier changed the earliest return date for the container, delayed the arrival of the vessel, or rolled the exporting booking to a different vessel with a different schedule. Also, congestion surcharges that are not properly justified by an event or condition that requires a surcharge, or provide sufficient explanation on when the charge will no longer apply. This is not an exhaustive list. The new charge complaint process does not cover charges invoiced or assessed prior to the effective date of ORSRA on June 16, 2022, charges that have not yet been invoiced or assessed by the common carrier, charges assessed by a marine terminal operator or party other than the common carrier unless assessed on behalf of the common carrier, charges assessed on export cargo loading on a vessel at a non-U.S. port or on import cargo discharging from a vessel at a non-U.S. port, which is not common carriage under the Shipping Act, and complaints related to other carrier actions that does not dispute an assessed charge. Charge complaints can be submitted by email to chargecomplaints@fmc.gov. There is no filing fee or forms to fill out under the interim procedure. A charge complaint submission should include the following information: identification of the common carrier, description or statement on how the charge or fee violated 46 U.S.C. 41104A or 41102, supporting documentation including invoices, bill of lading, proof of payment for the charges or fees demanded, screen captures of denied booking appointments for return of equipment, gate closures, or relevant emails also can be provided. Commission staff will acknowledge receipt of the submission and review materials provided to make sure all materials needed are included so that the Commission can move forward with its investigation. To ensure timely processing of a charge complaint, You need to provide shipping documentation with the submission, including bill of lading and documentation showing all the parties involved in the transaction. In some cases, the parties involved in the transaction may be just the common carrier, the respondent, and the shipper, the complainant. In other cases, in addition to the common carrier and the shipper, there may be other parties involved in the transaction. For example, a trucker or freight forwarder that was paid. If the commission staff have questions about your submission, you'll be contacted for clarification or to provide additional information. Let's walk through a typical charge complaint file at the FMC. Once commission staff receives sufficient information from you and determines that the complaint meets the charge complaint criteria, staff will promptly investigate the complaint. If the complaint does not meet the criteria, staff will notify you in writing via email and assist you in finding other avenues available at the commission that might be more suitable for resolution of your complaint. Once the FMC has sufficient information that the complaint meets the criteria, the FMC will open an investigation. Investigations will be handled expeditiously. The common carrier will be contacted by commission staff and asked to respond, justify the charge or fee under investigation. The common carrier can provide supporting documentation it may have regarding the fee in dispute. Commission staff may also reach out to third parties as necessary. For example, the trucker or MVOCC identified on the shipment documentation. Upon completion of the investigation, commission staff will notify all parties of the outcome. There are several possible outcomes for charge complaint investigation. The most common outcome involves the carrier either waiving the charge or refunding the charge after reviewing the particular circumstances surrounding the disputed charge. Common carriers, more often than not, choose this option once they have been notified by the commission that an investigation has commenced. If the investigation supports a finding that the common carrier charge is not in compliance with the law, the parties are informed that the matter will be referred to the Commission's Office of Enforcement for further Commission action. The charge complaint filer would no longer be involved in pursuing the matter. Under the FMC's interim process, the Office of Enforcement will pursue the charge complaint. If the charge complaint investigation does not result in a finding that the charge violated the law, the filing party and common carrier will be so advised. An investigation that does not support a violation is closed and the parties are notified. However, as discussed earlier, you're not barred from filing a subsequent small claims or formal complaint with the Commission based on finding of no violation under the charge complaint procedure. Likewise, you're not barred from seeking assistance from the FMC's Office of Consumer Affairs and Dispute Resolution Services or reporting a law violation to the Commission's Bureau of Enforcement Investigations and Compliance for potential prosecution.
Let's turn now to what happens after the investigation. For matters where an investigation supports a finding of a violation of the law and where the dispute has not otherwise been resolved, the Office of Enforcement will recommend that the Commission issue an order to show cause to formally adjudicate the charge complaint. The Commission will consider and vote on the order to show cause recommendation. Based on the Commission's vote, it will either issue the order to show cause or not issue the order to show cause. If issued, under the Commission's regulations at 46 CFR Section 502.91, the order to show cause will define which procedures will apply, such as submissions comprising only affidavits of fact, related documents, and memorandum of law. Additional procedures, such as evidentiary hearings, must be requested if desired. An order to show cause will name the specific common carrier and actions alleged to have violated the law. The order directs the common carrier to show cause why it should not be ordered to refund the fees or charges paid or waive those fees. The common carrier then has a formal opportunity to respond. Common carriers can provide affidavits or documents containing additional information related to the charge in question. The Office of Enforcement may then formally respond to the carrier submissions. For demurrage or detention charges, the common carrier bears the burden of proof for establishing the reasonableness of those charges. The complainant is not a named party in the order to show cause proceeding. No appearance or further participation from the complainant is required in this process. Instead, the Office of Enforcement pursues the refund or waiver arising from the carrier's failure to comply with the law. Timing. This is meant to be a faster, more nimble process than traditional proceedings before the FMC or courts. Carriers may voluntarily pay the full refund or waive the charges to resolve the complaint before the order to show cause is issued, and the complaint will be closed. The cases will move forward to a decision within a few months, not years, as may sometimes be the case with formal proceedings before the Commission and litigation before the courts. Refunding or waiving the charges is the only remedy for the complainant under a charge complaint. No additional damages are awarded. If the Commission determines, based on the responses to the order to show cause, that the assessed charges are compliant with the law, there will be no refund or waiver ordered, the case will be closed, and the complainant will be notified. If the Commission orders the common carrier to issue a refund or a waiver, a separate civil penalty proceeding may be initiated and referred to the Commission's administrative law judges for consideration of penalties. This is an entirely separate proceeding handled under the Commission's more detailed rules of practice and procedure and could result in a penalty. If a civil penalty proceeding is warranted and civil penalties are assessed, they're turned over to the U.S. Treasury. Interim procedures allow the Commission to continue to take prompt action to process charge complaints. In the 6 months since the passage of AUDRA 2022, the FMC opened 69 charge complaint investigations. 47 of those investigations were either completed, meaning the carriers voluntarily issued a refund or waiver, or the case was closed. 17 of those investigations determined that the evidence did not support a claim that the charges were not in compliance with the charge complaint sections of the Shipping Act. Those shippers were notified of this determination and given other potential avenues at the FMC for pursuing their complaint. 3 cases were referred to the Office of Enforcement to move forward with the order to show cause process. As of February 2023, 2 carriers voluntarily refunded the charges before the order to show cause was issued, and 1 was sent to the Commission and an order to show cause was issued to the carrier. That process is ongoing. The charge complaint procedure is already having success in driving informal settlements and waivers of demurrage and detention billings. The Commission encourages such settlements when mutually agreed upon by the shipper and the carrier. To date, over $700,000 has been refunded to shippers by carriers under this procedure. Experience gains from these interim proceedings will guide the Commission on what form a permanent process should take. A permanent procedure will be completed through the formal rulemaking process after notice and public comment. The FMC will use this process to conduct prompt investigations and proceedings to order refunds or waivers when appropriate. Common carriers who do not voluntarily issue refunds for non-compliant charges may be ordered to issue refunds and may also be subject to civil penalties. In the near future, the need for charge complaints may be impacted by the FMC's current demurrage and detention billing requirements rulemaking. This rulemaking, still underway, is seeking to bring more clarity, structure, and punctuality to the demurrage and detention billing practices of common carriers and marine terminal operators. If this proposed rule is ultimately adopted, carriers, both vessel operating common carriers and non-vessel operating common carriers, as well as marine terminal operators, will all be required to issue bills and invoices for demurrage or detention that are issued only to parties they have a contractual relationship with, are clear regarding the nature of the charges, are issued within 30 days after the charges stop accruing, and provide 30 days to dispute the charges with clear information about how the charges should be disputed. This rulemaking may lessen disputes and the need for refunds for charges because, among other things, it will make clear who is responsible for the charges and may help the parties communicate more clearly on situations where charges should not have been assessed. Regardless of whether this rulemaking lessens potential complaints about demurrage and detention bills and invoices, the FMC will remain committed to promptly investigating and processing the charge complaints it receives. The interim procedure will continue, and there will be a rulemaking for the final charge complaint procedure with public comment that includes lessons learned from the interim procedure. This concludes our presentation. Thank you for your interest in learning more about the Commission's new charge complaint procedure. For more information, including the charge complaint interim procedure guidance and links to the statutory language of AUDRA 2022 and the Shipping Act, you can go to our website at www.fmc.gov. If you have questions on the charge complaint process or AUDRA 2022, please email the Office of the General Counsel at generalcounsel@fmc.gov. And if you have a charge complaint, please send it to chargecomplaints@fmc.gov.